This is State of Nevada versus Snap Inc. I understand, but that's the other, the primary thing today is not the Rule 16. It's the motion, which is on page 13. We have the Snap matter for the record on 2 calendar pages because we understood from Chambers staff that you wanted to still have a Rule 16 conference and have some discussion. We can see a little bit of a divergence of opinion, although not really a huge divergence in dates between the parties on the Rule 16 to decide how the stay, if granted, or at least the pending appellate matter could affect those dates. So I don't have a problem with us talking through that and working out any other issues that we have. But I did want to start with the page 13 matter, which is the motion for stay of discovery pending resolution of the petition for writ of mandamus. Okay, so, and I would note that, and I apologize for the prior confusion. I think we got that cleared up. I had not connected to the prior record from the predecessor judge of the video approval for media request and order allowing camera access. That's the only reason I was asking in the chat what the recording was, because I didn't realize that existed. That's been provided. So whatever recording is to take place, whatever observing is to take place, perfectly fine, always is typically. I just wanted to make sure we had the right paperwork in place as needed. So let's go ahead and state your appearance.
And if, sorry.
Samantha Feely, bar number 14034 with the state of Nevada.
All right, thank you.
And then, so, okay, the screen just went back on. We also had Katrina Stark as well for the state, Your Honor, observing via Zoom.
Ms. Feely, are you with the AG's office? All right, and then we have counsel, and thank you for introducing everyone. Everybody welcome. Appreciate Mr. Fugazzi. You've got a huge pile of people over here and you're just by yourself.
Luckily, it's not a tug of war competition. Alex Fugazzi, on behalf of defendant Snap Inc. I do believe my one of my co-counsel, Amy Van Gelder, is on Zoom as well, observing.
I do see that. And I appreciate everybody being muted. I trust everybody can hear us. I'll give a half a second while I give a few thoughts that if anybody, I guess I wouldn't know how to ask, but the other folks who couldn't hear us put something in the chat. So if anybody's having any difficulty with reception, hearing, connectivity, or whatever, this is hopefully they'll see you all standing up here and realize it's time to let us know. Like I said, I am going to go ahead and have a brief discussion after we address the stay matter of the scheduling order and order setting civil jury trial and counter call, which would be our result typically of a Rule 16. But I appreciate the Rule 16 can take other issues and matters into account. So why don't we go ahead and everybody have a seat except for the moving counsel, who will help us understand what you want to highlight from the argument. I will tell you, I think the briefing was very thorough. I think you've addressed all the components of the things that the court would have to consider, whether or not to grant a stay at this level. And we understand that the writ petition is getting full review, scrutiny. I believe, is it tomorrow that the additional final briefing would be due in that matter that was called for by the appellate court. So we know at some point, I think, in relatively soon that we will be, we would expect to hear their result of their petition. But in any event, whatever it is that you want to highlight, of course, regarding the request for the stay while that pens, Mr. Fugazzi, will start with you, and then we'll hear from Mr.
Thank you, Your Honor. May I go to the podium?
Yes, what did you want to say, Mr. Spence?
Yes, Your Honor. I just want to clarify that Mr. Gayan will be making the argument on behalf of the state with regard to the motion to stay.
Okay, thank you.
Thank you, Your Honor. And I do appreciate, and I know you read everything. I'm not going to regurgitate the entirety of the brief. What I wanted to highlight for you are two things. One is the timing. We filed our writ reply yesterday. So as of yesterday, the writ.
It's yesterday.
But we filed it 2 days earlier.
Okay,
So
it was the 22nd. I was
correct.
wrong about that.
You're right, Your Honor. June the 22nd, we filed yesterday. So the writ as of now is fully briefed. I think another data point that may be of some interest to the court is that the court has granted oral argument for the TikTok appeal. And while that's a different case than ours, TikTok filed or TikTok writ. TikTok did writ similar issues, First Amendment in Section 230. The Nevada Supreme Court set argument for that on June 4th. So that is also upcoming soon. So how that impacts us, or whether that impacts, I don't know, but I just note that this seems to be front and center with the Supreme Court, and the Section 230 and First Amendment issues are on writ by TikTok, similar to us.
There doesn't seem to be any doubt that the appellate court is really trying to dig into these issues and figure out, and as you pointed out, some of them go to if the court even has the jurisdiction to hear this, and on what basis would this case even proceed at all. So I do hear you that they're showing that interest. I remember when I first took the bench all those years ago, one of the training components about, the cases and how they unfold, and the appellate courts and the numbers that they would give is how very, very few writ petitions even get heard or attention, period, that they're usually denied. You've got your plain speedy remedy by going through with your case at the district court level, do it, and then whatever happens, we'll decide from there. And then even rarer sometimes, even if it gets really considered, is full briefing. And even rarer still would be oral arguments. So there's no doubt in this court's mind that the appellate court is giving this due time and attention. I guess the question that begs in my mind, and I don't want you to not highlight anything you want to highlight, but the question that begs in my mind is, would not it make more sense that it be denied at this level where the court believes that there are potential, the balance of the interest between the parties and who might be harmed if the stay is or is not granted. When we do all of that analysis, of if the court's opinion there was that it should deny the stay at this level, but in the end, wouldn't it make more sense for this court to deny the stay at this level, but allow you to go to the Supreme Court to get their understanding of whether a stay is needed? They are the ones, right, who would know their intentions with the TikTok case, this case, whether or not they're going to set that for argument, whether or not they connected those two things, which I'm quite sure they have in terms of what's pending before them. Would it not make more sense to get sort of their input on if they think a stay is necessary?
I don't disagree with you, Your Honor. I do believe that should this court deny the stay, we will, with great haste, be filing our motion to stay with the
I
Nevada
assume
Supreme
that you
Court.
would, sure. But like you said, you've asked for it here. And obviously, if the court, to make its final determination, does have to consider all of the factors in play, and the briefs do address, and if you would like to address that, whether the object of the appeal would be defeated if the stay was denied, and then, of course, the irreparable or serious injury either way, whether the entity bringing the writ would have irreparable or serious injury if denied, or the party objecting to the writ or opposing the writ would have irreparable or serious injury if the stay is granted. So however you want to address those points.
Yeah, thank you, Your Honor. And I would start with just the thought when I was pointing out to you that we would be filing our motion to stay with the Nevada Supreme Court very rapidly, 24, 48 hours tops. The reason why I think, should the court deny our stay here, the reason why I think that might be noteworthy to the court is that if you deny the entirety of our stay, consider at least granting a stay for 30, 45 days to allow the Nevada Supreme Court to weigh in and determine whether it is going to find this meritorious enough to grant the stay. I don't know that there's I guess there's a bit of a spectrum here to what the court could do, right? On the one hand, you could grant our motion, which I'd be very appreciative of. And on the other hand, you could grant it for a finite period of time with clear instruction. I know the rules of appellate procedure require us, I think if you give us a stay to file within 14 days, we would file it, if not today, tomorrow, I believe. So for context, to the extent that's helpful.
What would be, and to the extent that you addressed this and I didn't connect to it, I do apologize, but there's been reference obviously to, and we didn't really address yet, the supplemental briefing and the motion to strike that came in after 5 o'clock, at least 1 minute after 5 o'clock for what that's worth yesterday, that we didn't see till this morning. But at the end of the day, when all the dust settles, the good faith, as you put it, I believe, participation in what's been going on so far has been happening. What's next that's going to stop or not stop, as the case may be, depending on this court's decision?
So what has the status is currently, we have 71 very broad document requests served upon us. It's an exhibit to our motion, and this is a big case. So, we'll deal with that, and we're set to negotiate with the state should the stay not be granted by this court. But these are significant, voluminous, burdensome document request served upon us. And if in fact we are correct, and the state of Nevada has no jurisdiction over SNAP, requiring us to go through that burden is simply improper.
And when would they be due?
We have negotiated with, I believe, June 11th is, I think June 7th, June 11th, sometime right around there is
In
when
that second week of
those,
June?
we got a 30-day extension for the state with an agreement that we would negotiate and talk in the next week about status and where we are. So
Okay,
that's where, so that would be due first or second week of June. So that is the big thing facing us right now. If I could touch on the factors, and again, I'm very
Please.
cognizant that you have read the briefs. I'm not going to regurgitate the briefs. But factor one is the object of the writ will be defeated if the stay is denied. And the state focuses on the Hansen case. And if the Hansen case is the one that I'm most familiar with because it is the general versus specific appearance, sort of the absolution of general versus an appearance is an appearance, and you don't waive. You don't have to sort of straddle this general versus specific. Hansen does also talk about denying a stay in the personal jurisdiction context and that not being unduly burdensome or irreparable. That's a 2000 case. The case we cite for you, however, Your Honor, is the Viega GmbH case. And that's a 2014 case. That case is 14 years newer. And although it doesn't explicitly overrule Hansen, I think it's fair to say the Nevada Supreme Court may be of two minds on this, or at least the fact-specific inquiry, because here's what Viega in 2014, again, 14 years more recent than Hansen said about personal jurisdiction. It says, as no adequate and speedy legal remedy typically exists to correct an invalid exercise of personal jurisdiction, a writ of prohibition is an appropriate method for challenging district court orders when it is alleged that the district court has exceeded its jurisdiction.
I mean, that's a method. Does that speak to the stay piece? Because the part that I was focusing on, and from all the case law that was cited, but the part that kind of resonated with me is we're talking about litigation costs. And the case law doesn't seem to support that litigation costs alone are irreparable harm. So again, I'm
Yes,
really trying to focus on
So,
it, but
I-
I hear you and I don't disagree with
No,
your assessment
no.
of Viega.
I anticipated your question. Footnote 5 of Viega says, in light of this opinion, we vacate our June 13th, 2012 order staying the district court proceeding pertaining to Viega GmbH International. So this is footnote 5 tells us that on June 13th, 2012, the Nevada Supreme Court granted a stay and it issued this opinion on May 29th, 2014. So I read footnote 5 as saying, yes, a stay was granted. And now that the Supreme Court has decided the writ, that is decided, there is no need for the stay. So that's how I read footnote 5, Your Honor, as a stay was
And that was
granted.
a Supreme Court stay grant, right?
It is, yes, it's
Yeah.
Viega GmbH, 130 Nevada, 368, 2014.
Okay. Anything else you want to highlight from the factors?
There is, Your Honor. The object of the writ being defeated is not just the jurisdictional issues, but it is also the actual substance of our claims. The First Amendment in Section 230. These are statutes that don't just prevent liability or statutes in a constitutional amendment. These are statutes that are immunity statutes. So, example, for the First Amendment, we cite the Green versus Miss United States America. That's a Ninth Circuit case that says the First Amendment protection extends not to just unconstitutional laws, but unnecessary litigation that chills speech. So the very act of making us proceed with discovery, with litigation, when potentially the Nevada Supreme Court may agree with us that there is a First Amendment protection, would be a basis to grant the stay. It's not just an ultimate liability, it is unnecessary litigation. And similarly, Section 230, here's the Ninth Circuit in the fair housing case, says Section 230 also, quote, protects websites not merely from ultimate liability, but from having to fight costly and protracted legal battles. And that's the case that talks about something like death by 10,000 duck bites. That's the one I remember that one, which is kind of the point. And again, these are the bases for statute. So that is the object of the writ would be defeated, Your Honor. The balance of the harms, interestingly, we have cited, I think it's the Robles-Nieves case. That is a criminal case where the Supreme Court granted a stay despite the constitutional right to a speedy trial. And even in that case, upon balancing the hardships, the court still granted a stay. So the argument here about the state being that their harm is worse than ours directly harm in a civil case, I think really is belied by even the criminal cases we've cited, where we know there's the constitutional right. All of us who get bumped off of stacks for criminal cases know that the criminal cases have a constitutional right that we do not have. With regard to the balance of harms for SNAP, it is the Micon gaming case, insufficient as a matter of law. Quote, a mere delay in pursuing litigation normally does not constitute irreparable harm. However, there are circumstances where, when you're dealing with the First Amendment immunity, when you're dealing with the Section 230 immunity, where it would be appropriate. So the last one is the likely to prevail. And this is always a tricky one, because the standard per Hansen is that SNAP must be able to present a substantial case on the merits with a serious legal question. It is not asking the district court, who gave this a lot of thought and consideration, and even on a reconsideration, to say, shucks, I might be wrong. That's not what we're asking. That's not the standard. It is a substantial case on the merits with serious questions. The motion to dismiss briefing was significant. The amount of time the court took to consider which order to sign was significant. This is a serious case with serious legal questions, which again, I think go towards the likely to prevail elements. So I have lots more I could say, Your Honor, but the briefing, as you said, was fairly thorough. So to the extent, if unless the court has specific questions, I'll save my final words for a vote.
I don't have any additional questions from the ones I've already asked, and as I said, yes, the briefing was very, very thorough, and I appreciate you touching on the factors and indulging me with sort of getting a better understanding, because the court wouldn't be privy to that, of what discovery is pending and the concerns. And maybe, I guess, as I'm saying that out loud, the case law that would support the argument that litigation costs, which is really all that you are facing at this stage, is really not typically irreparable harm, or the type of harm that should be considered, maybe. It wasn't clear to me that it should be given less weight. It appeared clear to me that it's not really the thing to be considered. Is there something else? Is the business going to close down? Is there something that's happening that's going to be so significant that the business can't survive? Like, that's not what we have here. You're talking about burdensome litigation costs, and we can certainly understand 70 some odd requests with very broad, documentation requests is important. But, on the chance that the appellate court says that this case still has life, and the appellate court agrees with this court, and perhaps whatever it does in the TikTok case, then, informs on this case. But in any event that these cases do not go away, would it not make sense that discovery still be had, even though it would have some litigation expense to it, that discovery still be had, so that when the court denies, if again, the court would deny the writ, that we're ready to keep proceeding? Because otherwise, if we stay everything for litigation costs only, which appear to be the issue, then aren't we just delaying the case in a way that's unnecessary? I guess is my question.
I think the best way I can answer that, Your Honor, is if this was a breach of contract case where we were dealing with contract formation or something along those lines, I would not have a great response to you. But in this case, our specific affirmative defenses are First Amendment and Section 230. Those are immunity provisions. The fact that we have to litigate is violative of those provisions, and that's spoken about in the Green case and the Fair Housing Council case.
Well, that seems a good place to segue over then to counsel who's going to respond.
Thank you.
Mr. Gayan.
Good morning, Your Honor. I'll try to be brief, but there's a lot of problems with SNAP's position here. We put them in our papers. I hopefully don't have to address the notice of supplemental authority and the motion to strike. I mean, that we put it in our response. The TikTok stay order is completely irrelevant, and it's not a procedurally proper filing. So
let me take the opportunity, since you did bring it up here, and it would be a good place in the record to do that. The supplemental authority that was provided, and I believe that filing date was May 13th. If there was going to be a request to strike it or an objection to it, that should have been filed, in my opinion, long before 5:01 yesterday. The court did not see the motion to strike. The court does not have, as the rules would require, at least one judicial day to get it set to hear the motion to strike. So the motion to strike, respectfully, procedurally, is denied. But I will indicate to you that even though there was the supplemental authority, I tend to agree that what occurred in that circumstance is not necessarily certainly not binding and not necessarily persuasive here. I am focusing on this case and this case alone and the factors in this case and what we know to be going on with our appellate courts at this time in both this case and other, I won't call them related, but similar cases, okay? So
That's a great segue to my next
we'll
point.
just put that way.
So there is great disparity on how the Nevada Supreme Court is treating these social media company writs. Meta, for example, filed 3 writs in the 3 different cases pending directly above us in 16B, and the Supreme Court denied all 3 writs. Meta filed petitions for rehearing. Those were all denied. And now Meta has filed petition for en banc reconsideration that is pending. So the court,
But would you concede that those meta cases have not, what, I guess maybe not ask the question because I can't, as I sit here today, say that I have memorized the meta decisions, but would you say that the issues that are raised here, as Mr. Fugazzi pointed out, which could be, determinative of jurisdiction or immunity are addressed in the meta case or
yes,
not?
that is the exact same basis or bases that Meta filed writ petitions. Tricarchi, personal jurisdiction, specific personal jurisdiction was found by Judge Kishner against Meta in all 3 cases. Judge Kishner, like this court, determined that Section 230 and the First Amendment did not bar all the state's claims. And that's exactly what this court decided. And Meta filed writ petitions on those exact 3 issues, same as Snap, and those writs were denied. TikTok filed almost an identical writ. State was directed to answer. We did. It's fully briefed and it's being heard on June 4th. And so my point with all of that is I think the court's very first question is, shouldn't this court deny it and let the Supreme Court decide what it wants to do, because they know what they're up to and this court doesn't. And it's unclear to me and the state, and we have appellate specialists on our team who can't quite divine what the Supreme Court is intending or up to in 5 writs challenging the same 3 legal things, 2 answers directed, 3 petitions denied on the papers with no answers directed at all. And
I have the same confusion, so.
right, and so I think denial is the only thing that makes sense here, just practically. And so, and I want to emphasize that SNAP has not and cannot meet its burden under the NRAP 8 factors. I know the court's questions are, you're being very practical, and that's common in these situations. But I wanted to clarify the record because I feel like there's some things that are not quite right here in the papers from SNAP, and then also in some of the comments here. So I guess I'll put a pin in the practical side of things, that the Supreme Court is better situated to decide this, as the court suggested. Now, Your Honor, I think, the most glaring thing to me is the fact that Snap is the only social media platform that filed these 5 writs and is seeking a stay. Meta never sought a stay. TikTok didn't seek a stay, and we're moving forward in those cases. So just like the Meta Massachusetts one, that's moving forward in discovery.
But they sought the stay, so
Snap-
we have to address the stay.
They've sought the stay, but they wasted a lot of time, and they acted completely inconsistent with a party who believes. I heard counsel say that this is a serious case and they were going to file their motion to stay in the Supreme Court very rapidly. I think it was about 28 to 48 hours. Well, then why did, when this court set a separate hearing and gave a detailed oral ruling on October 1st, 2024, Snap knew what the court's decisions were going to be and that it lost on these 3 issues. It could have spent the next 4+ months preparing its writ papers, which are, frankly, a regurgitation of the motion to dismiss papers on all of these points. It didn't require new research. Mr. Fugazzi's office does writ petitions all the time. Ms. Dove does them. She's the one handling it. This is easy stuff. So it was all there. Why did they take from February 13th, when we got the court's written order, and we're not contending that they needed to file the writ petition before the written order, but they could have filed their writ petition promptly after that order, and they could have filed a motion to stay on order shortening time to avoid having to answer. They didn't even ask the state for an extension to answer because they intended to file a writ petition and seek a stay. It never came up. What was actually going on, and this is in the record, on the same day they answered voluntarily without ever asking for extension or seeking a stay. They answered with 51 affirmative defenses on February 28th. The court also signed the stipulated protective order that SNAP agreed to and the stipulated ESI protocol that the parties had been negotiating for months. We got SNAP's first red lines on those documents November 8th, 2024. Why would a party who thinks it has no obligation to litigate in this forum negotiate those documents, stipulate to them, and have them entered in the case the same day they voluntarily answer without ever raising the idea of a writ or a stay? Then they waited a month to file their writ, another month to move to stay, didn't move on an order shortening, didn't seek an order shortening time. So here we are, May 19th. It is more than 3 months after the court's order.
So counsel, I hear you, but I just really would like to redirect you to address the factors, like whatever brought SNAP to the place that they decided at this time to seek the stay. And that may very well be because they've decided to seek the stay above us and they can't do that unless they ask us here. How we got here doesn't appear to be relevant to the factors. Can we just address
It is,
the
Your Honor,
factors?
maybe I'm not being clear. The very first.
Well, you're not cutting to the chase. Let's cut to the chase.
Okay.
It's 11:20 and I got other things I have to hear besides this, but we're gonna give this all the time and attention it needs.
I'm not being clear then. The first factor under NRAP 8 is the object of the writ. And SNAP, like many other movements, are misidentifying the object of the writ. They're saying litigation expenses. They want to avoid litigation. Well, they've done nothing to avoid litigation to get here today. In their reply, they say all those other things are required by the rule. Stipulated protective orders and ESI protocols are not required by the rules. They did plenty of voluntary things that cost a
But
lot of
those
money.
aren't the same, oh, I really don't want to get in the weeds of this, but let's ask. In my mind, I am familiar with ESI protocols, with protective orders, reviewing, signing off on those. That's not the same thing as responding to a 70 request for productions of documents, is it? Like how those things can be done. And the argument that those things were done in good faith, I mean, I hear you. And if you're putting it in the box of the first factor, then so be it. But I'm still not seeing, that's why I asked what exactly is pending. It makes sense to me that they would ask. I'm not saying that means that factor is weighing in their favor. I'll give a final determination on that, but the history, it seems like it's more just being brought forward to say, look, they could have done this sooner. They didn't. They participated. We think that means that in the end, that there's no defeat of the writ. Well, at the end of the day, they're saying we shouldn't be in this case at all.
Okay.
Clearly, if we force them to continue to spend money in this case, potentially that is defeating the writ if they shouldn't be having to spend any money at all at this point in their opinions.
Okay, I understand the court's comments. Let me make some additional points on the object of the writ. SNAP is being sued by many other states around the country. It responded to pre-litigation investigations by attorneys general around the country. It has gathered and produced many, many documents. So that important fact has not been provided to the court by SNAP. They have the burden to show that this discovery would be so burdensome. Many of these documents have already been gathered and produced in similar investigations engaged in by other states. SNAP has not mentioned that to the court. So yes, 73 RFPs, but the state of Nevada did not do a pre-suit investigation of SNAP. It does not have SNAP's documents yet. And those RFPs are largely designed to get the documents that SNAP provided to other states and has been producing in other litigation around the country. So there's no sign of any burden whatsoever. In terms of the object of the writ being defeated, the true object of the writ is, if the court takes a step back, personal jurisdiction. This is not the Vega case. I actually did the Vega case a long time ago with Randall Jones. That was against a German parent company. That's very different than what we're talking about here, where we have SNAP as a domestic company. Even if the Supreme Court agrees and says this court doesn't have personal jurisdiction over SNAP, it just means the state of Nevada will sue SNAP somewhere else in this country. The litigation will proceed. It doesn't mean that the litigation is over. So there's no waste in doing the work as the court suggested before. We should get moving along And whether it's here or somewhere else, this case will go forward, and we're confident it will go forward in this court with your honor. And similarly, and so SNAP is just painting this whole object of the writ with too broad of a brush. Same with the section 230 and First Amendment arguments, your honor. I'll just point the court back to its order denying the motions to dismiss. The court said for both of these issues, and this is on page 5 and 6 of the court's order, the court specifically said, and this is the top of page 6, that section 230 does not preclude the state's claims in their entirety on the pleadings. And that was the same ruling for First Amendment. So if that's not the case, it's not case dispositive. The case is not over. And SNAP has not said which portions of the state's case those immunities would potentially apply to. And so they're just trying to throw the baby out with the bathwater and paint with too broad of a brush. And that is just not the case. So the object of the writ, they cannot demonstrate. In terms of the burden, I think I've already addressed that, your honor. And in terms of the merits, I think the court, that one's always a tricky one for the moving party because they obviously lost at the district court, and to say that the district court got it wrong is difficult. And that's why, again, it might be better to just move that decision to the Nevada Supreme Court and let them decide whether a stay is appropriate. But, you know, since this court decided, I think it's relevant to point out, and we put it in our papers, the en banc Ninth Circuit in the Briskin versus Shopify decision, pretty resoundingly rejected the differential targeting argument that internet companies have been using in terms of personal jurisdiction. And all you need are the regular minimum contacts, which this court found in factual findings that SNAP had. So I don't think jurisdiction has a realistic chance, but ultimately the Supreme Court will decide that. And I think the same issues occur with the Section 230 and First Amendment arguments. Even if that immunity does apply, it's fact specific. I will point out that writ relief on a motion to dismiss order is, quote, is highly disfavored. That's repeatedly been stated by the Supreme Court. So there's only very narrow circumstances here, and there generally cannot be any fact issues if you want writ relief on a motion to dismiss order. And there just are fact issues on all of these issues: personal jurisdiction, Section 230, and First Amendment. So a Rule 56 motion would be more appropriate for these types of defenses anyways. And again, they're not waived. So there's no harm to them. Happy to answer any questions.
I don't have any further
Thank you.
questions. Thank you, Mr. Gayan. Final brief word to you, Mr. Fugazzi.
Yes, Your Honor, brief words. First of all, TikTok versus Meta. The reason why Meta, that stay was denied and the writ was denied, my understanding is the state filed an amended complaint. Meta has filed an amended motion to dismiss, and that's back at the district court. I believe that's why there's disparate treatment by the Supreme Court between TikTok and Meta. So, but I'm surprised appellate counsel are all stumped by that. But that's my understanding of why they're being treated differently. And again, when I first started arguing today with you, we talked about how rare writs are to have fully briefed, to have oral argument, and the fact that TikTok is proceeding, I think means the court is giving this, the Supreme Court is giving this a hard look. Very briefly, I don't think these delay allegations are particularly moving the court, but you know, timeline is important. February 13th, you signed the order granting in part and denying in part the motion to dismiss. We filed our writ within 30 days of there on March 11th. We filed our motion to stay on April 8th. I've never been lambasted so much for actually cooperating and complying with the rules. Until you say there's a stay, my understanding is I got to comply. I got to file a JCCR. I got to answer. If it was the world of court and Alex, things would be a little different. But that's my understanding. So I've never been lambasted much for cooperating with you or for cooperating with counsel and proceeding. The argument, I'm a little bit confused about. The litigation isn't over even if we prevail on our writ. Our writ papers are clear. If there is a First Amendment, if we are correct that First Amendment and or Section 230 provide immunity, that does resolve all claims, at least that's how we have presented to the Supreme Court. Again, the Supreme Court could parse it, but our briefing is clear. This would be a resolution of all claims. The argument that there's no harm because the state of Nevada would simply go somewhere else and file the same action with us. That's true of every single personal jurisdiction defense or case, and yet stays are often granted on personal jurisdiction grounds. The idea that the discovery is not burdensome to us because we're involved in other litigation. I'm just looking at our exhibit 3, and I'm just sort of doing this on the fly, but the request for production number 28 is targeted to documents sufficient to show things in the state of Nevada, documents directed at the state of Nevada. There are all present communications to you that impact Nevada. All marketing and advertising you conducted for Snapchat that ran in the state of Nevada. These are document requests that have not been served upon us in pick your other state. So these are different requests. There is not simply a easy button that we push to produce everything. The Briskin
I kind
versus
of took the argument on that differently. It wasn't that it was, you can just cut and paste from other discovery responses to complete these. I think the acknowledgement was that these were specific to Nevada, and that the discovery that you had given out or the responses that you had done in the past were not the same because those did not address Nevada. But the point being that they should still be able to receive that and keep that going, because otherwise SNAP has been participating with these things generally in other states. That I think that's the point I took.
okay,
from it.
if that's the point, then I miss it. I thought it was they're all sort of the same and there's no burden. Because I think I heard the words, we needed to come forward with explaining why there was a burden. And again, when I look at a lot of the requests, they are directed at Nevada. The Briskin versus Shopify case, briefly, Your Honor, that is why we filed the notice of supplemental authority. I know the state relies heavily on that case and that impacting the likelihood and the nature and object of the writ. The exhibit we attached is a district court order granting a stay after the Briskin versus Shopify case. So someone wasn't wholly persuaded that carried the day. That was the point of that, Your Honor. And again, I will fall back on this. If you are not inclined to grant our stay in its entirety, I would ask that you at least consider granting us a temporary stay to allow the Nevada Supreme Court to decide what I do think is a serious, complicated issue that's worthy of a stay, particularly given our Section 230 and First Amendment defenses.
All right, I thank you for the opportunity really to flush out the briefs here today. And I have given it a lot of thought in reviewing the written briefs, and I always do everything in my power to come in and into the hearing with an open mind to see if there is anything that, you know, further informs, so that the court can make the most fully informed decision it can. And it is this court's determination at this time respectfully to deny the request for the stay at this level, and to expect that SNAP would seek the stay from the appellate court, who I think this is not the reason for the decision. I'm going to address the factors briefly, but I think the appellate court is in the best position to help the parties understand where it might be going at this time and whether or not it thinks a stay is appropriate, because I cannot connect to why we have these differences of opinion, so to speak, where I would say there was sort of a relatively quick response with Meta, and now we are digging in and giving full, briefing. Sometimes there isn't even a reply allowed. I mean, the rarity of this it points to, and I think does show, the seriousness of the case and the issue. Now, that would be a potential factor weighing in favor of SNAP. I get that. But in the end, I think when you look at the factors, they do militate against the court at this level granting the stay, and I'll explain why. But I do expect that they would seek the stay from the appellate court, and then that would give some insight as to how they intend to address this, with what quickness, if you will, they seek to address this, or if this is going to be an aspect of this that needs to be taken out. Ultimately, I believe that the factors ultimately weigh in favor of the state's arguments and militate against SNAP getting the stay at this level, is because it is hard to see where the object of the appeal of the writ in this case would be defeated. In that, of course, we understand that the arguments could end up with jurisdiction being found lacking, or the liability being found not attachable, so to speak. That in the end, there would be an outcome that could be favorable to SNAP. We see that, but what we are talking about here is ultimately a Court of Appeals decision. I very much connect to Mr. Gayan's arguments that these are factual disputes that really have to be determined, and it's very hard to see how the court is going to make, the appellate courts are going to make a decision as a matter of law, that whether it's under the 230 provision, First Amendment or otherwise, how they're going to say if this case is over and it's not going to proceed here. I think there's certainly the general understandings that jurisdiction cannot be something that's later cured. If it didn't exist, it didn't exist. But what we're ultimately talking about is a writ to ask for these things to be reviewed. But in the end, what's being juxtaposed against what would happen in between if we don't grant the stay is litigation expenses. And it's just not this court's connection that is the kind of irreparable harm, serious injury. So even if it's a close call and maybe SNAP slightly prevails in the argument that there could be some, defeating of their writ effort, because what they're asking is for the appellate court to say we shouldn't have this case down here, and they're still having to proceed with this case down here. Okay, but it's still pretty close. But where SNAP ultimately cannot prevail is when you look at, are they going to suffer irreparable serious injury? This is litigation expenses that is not determined to be that. And it can conversely, the state suffer the either irreparable or serious injury. The state is pursuing something that it believes is appropriate in this jurisdiction on behalf of its citizens, and the ongoing, you're arguing a little bit about how operations are harmful. Obviously, operations are ongoing regardless. There's nothing here that the state would or would not address that. But the point here being the ability to continue to discover, to find out what is happening in Nevada, to the extent that it's happening in Nevada, to be prepared to proceed with this case should the appellate court not agree with SNAP. I think that is the kind of injury, that is the kind of harm that would show that the balance of the harms, if you will, strongly favors the state. And then in the end, as I said, is this a serious legal question? It is. We're not going to get into the weeds of the likelihood of succeeding on the merits. I don't think here it's a merits question likely, but the likelihood of prevailing. I mean, obviously this court believes it got those questions right. It will oftentimes be told otherwise by the appellate courts, who can look at these things in a different way and in hindsight. But at the end of the day, I don't see where we see that ultimate fourth factor of likely to prevail on the merits occurring here, whether it be because there are too many factual questions for this case to end at this stage, or whether it be because the court is correct in its findings related to these relevant constitutional amendment and statutes. I don't know, but I think, in part, the fourth factor, it at first blush looks like it weighs in favor of SNAP, but in the end it weighs in favor of the state. Second and third factors weigh in favor of the state, and the only one that possibly weighs in favor of SNAP in this court's opinion is the object of the appeal potentially being defeated, and that's a very close call. So that's not enough to overcome the ultimate weight of the factors favoring the state, and the court ultimately denying the stay request on that basis. So I'll ask the state to please prepare the order denying the stay request. Obviously, Mr. Fugazzi, I believe you can still seek what you need to seek in the appellate arena, because when it comes to being able to show that the court was inclined to, you could even go up if you think the court would be inclined to deny the stay request. But we have a definitive decision today. There will be minutes, but in the end, you've heard it. We've said it here. You can seek the stay at any point you wish, but I would like with the order to be prepared as quickly as possible. We all know what the arguments were. We all know what the factors were. Just get the order done, because I'd rather have that clean and neat and signed off on, so that they can have the opportunity to seek the stay up in the appellate court, where I think the question does more properly belong.
Yes, Your Honor. Thank you, Your Honor.
As far as the Rule 16, I really do have to make this quick. Is that going to be you, Mr. Sykes, to speak into that?
Yes, Your Honor.
Obviously, the court is denied to stay at this level. I have no way to know for sure if the appellate court would grant the stay. The difference in dates really does appear to be nothing more than maybe a 30-day swing, give or take, based on whether we think the stay is going to have impacts or not. So do you have anything specific to add to what we could see in the joint case conference report about the dates, and then is there anything else that you wanted to address, because it was requested that it stay on the calendar today for whatever purposes the Rule 16 could serve, but I would like to try to get through this as quickly as possible.
Thank you, Your Honor. And respecting the court's time, we would simply request that the court adopt the plaintiff's proposed dates. In terms of the total discovery timeline, I think you're correct. There's a difference of maybe 30 days. I think what's kind of the more crucial difference, and the state would object to this, the defense does want to have staggered expert disclosures. I think a huge problem with that, Judge, is they have 51 affirmative defenses. Affirmative defenses meaning that they have the affirmative burden to prove those. And if there's expert testimony or opinions required to prove those, they have to set those out in their initial disclosures. So their argument that they want to wait and see what our experts say does not hold water, particularly with regard to their affirmative defenses. And it would not be fair at all for us to disclose all of our experts and all of their opinions, and then the defense gets to disclose their experts on their 51 plus affirmative defenses, and they get to essentially rebut our experts' opinions as initial disclosures. Not appropriate, Judge, and that tends to be pretty rare in the matter of practice in Clark County anyway. So we would object to that, and we think simultaneous disclosures, standard in Nevada, I think that's appropriate here. We did, just so your Honor's aware, and this is on pages 18 and 19 are the plaintiff's proposed dates in the JCCR. We did build in an extra 30 days for the rebuttal expert disclosures, and that was by design.
Okay, I did see that.
Yeah, so if a party, is somehow surprised by an expert or an initial disclosure, there's additional time built in for rebuttal reports and experts for that purpose. And to give everyone a little bit of additional time. The only other additional thing that the state requested that's not standard procedure, and I think the parties agree on this, the limit of 10 depositions, obviously that's not going to work in a case like this, particularly with regard to the number of experts I anticipate each side is going to retain. So we wanted to exclude expert depositions from the limit of 10 depositions per party. And I do believe the parties agree on that.
We do.
Okay. All right, Mr. Fugazzi.
Yeah, very briefly, Your Honor. Here are the points in contention from our standpoint. We have asked for a substantial completion deadline. There is voluminous document production. We are focused on doing expert reports, hopefully once, and expert depositions, hopefully once. And I don't really understand why both sides wouldn't agree on a substantial completion deadline whereby the majority of documents are produced in advance of expert report deadline so that we are not having endless supplementation. Many of the cases I work on have folks, for whatever reason, supplement late and after experts and almost on the eve of discovery. So we're asked for a substantial completion deadline in the hopes of avoiding that issue. The second issue is the staggered expert disclosures. The 2019 amendments do contemplate this option. In fact, I think one of the reasons why we have a Rule 16 conference is the court has discretion to modify Rule 16.1. This is, we are the defendant in a novel case brought by a plaintiff with a, I don't remember how long complaint. I think their initial reports and our rebuttals 60 days later is fair and relevant here. And particularly, here's one reason why. We all know the 16.1 A2E2 rule that talks about expert deadlines being due after initial reports, except for those opinions, quote, that should have been expected and anticipated by the disclosing party. This becomes an issue that I have dealt with repeatedly with fights and motions in limine over whether a rebuttal is a true rebuttal or one should have been clairvoyant enough to include it in their initial report. And I suspect it is very likely we will be before you, Your Honor, on that. This is effectively our staggered request, I think, is time saving and fair, not an additional burden. And I believe the last thing we asked for was dispositive motions being due. I think it was 60 days after the close of discovery instead of 30. Again, I'm anticipating a lot to deal with there. And then you're right on the discovery. I believe we're 1 month apart. We'd like our deadline, but I don't think that's you will make that determination. I don't think you need a lot from me on that.
All right, thank you for your brevity with going back through that. I had reviewed the, like everything in this case, the voluminous joint case conference report. The last question I guess I have, and I'm not sure, it doesn't seem that the parties disagree on this date, but where are we coming up with 8 to 10 week trial timeframe? Is that something that, based on what has gone in other matters, we think is necessary? It seems excessive to this court that it would take that amount of time.
And so it's based on a couple different things, Judge, and I'll make it quick. So one of them is, yes, we have seen in other matters, particularly matters involving states suing major corporations, that those trials can take months. And so we assumed, and the other reason is we rather kind of overshoot how long we think it's gonna take than undershoot. It could take, it could take 6 to 8 weeks. It could take 5 to 6 weeks. However, I know with the court's busy schedule, sometimes the court has half days, some days are dark. We were trying to take that into consideration when we planned out our trial days. If we had full trial days every single day, then yeah, 4 to 6 weeks. But the reality is we don't. And so I'd rather say 8 to 10, and just in case we need it, then say 4 to 6, and then it turns out we need 8 or 9 weeks. So that was the basis for that.
And Mr. Fugazzi, do you have any thoughts on that?
I do. The efforts to impanel a jury when you're telling them 10 weeks is really hard.
No kidding.
Really hard. I mean, 4 to 6 is hard. 8 to 10 is really hard. I think this court runs a pretty tight ship and is not going to allow a voir dire that is effectively putting on a case in chief that takes 3 weeks, which
You got that right.
I've seen before. And I think knowing the way you run your courtroom, I think 4 to 6 weeks is plenty of time that'll enable us to more easily impanel a jury and get folks who are willing to sit. And if when the more time you give us, the more time we will take. That's what lawyers do.
Just to touch on that point that you said, because it's probably not a bad idea. Counsel are familiar with the court, but just in terms of its thoughts about this case, where I 100% agree that the court's belief that jury selection, the purpose of jury selection is to find a fair and impartial jury. The purpose of jury selection is not to try to engineer that the people who are sitting there for that trial are going to be more favorable to one side or the other. And so in the end of the day, the court is going to keep voir dire and jury selection very tight. However, that said, one of the things that this court very rarely considers, and certainly very rarely considers in civil cases, is the jury questionnaire. And I would be potentially open to that idea, but that cannot be something that happens 30 days before the trial, right? This is going to take time. The jury services needs time. We need time for the review and the final decision making. So I'm not calling for it. And if the parties don't want it, fine. But I would potentially consider that in this case to aid and assist us in the jury selection process. But at this point, I'm going to consider this an 8-week trial. I'm going to go on the lower end of that scale. And because we potentially could, depending on what eventually evolves, and assuming we're even in trial in this case, that we might sacrifice some of those calendars, some of those dates, try to give you more full days, more time, because I am always mindful of trying to keep a jury in one place all that time, and what the harm and potential damage it could do to their lives. I think that gets forgotten and lost on the part, but I'll give an example of some years ago, the court's former JEA was pulled into a trial in one of the business court departments that was scheduled to take 4 weeks, with some final things having to occur. It eventually took 6, not all full days, mind you, but over a 6-week span. And this was incredibly harmful to this person. And I know that from firsthand experience, because of their efforts to try to juggle their job, which they could not put on hold, their efforts to be 100% there and attentive. And in the end, it was off-putting to this person, because in the end, it also appeared that this was kind of just a trial to experiment to see in the end which jurisdiction was going to be the most favorable or unfavorable, or what might be happening, but it really wasn't going to ever definitively determine the case. And that part aside, really the issue is we have to be mindful when we take people out of their daily lives for a trial that we keep it as tight and as efficient as possible. Okay, so those are those thoughts. I'm going to adopt the plaintiff's proposed dates with one exception. I'm going to adopt the plaintiff's proposed close of discovery, the final day to add file motions and pleadings. I am not going to adopt the defense request for staggered expert disclosures, so I would keep also the expert disclosure dates for the, that the plaintiff proposes. But I am gonna do, I think it makes sense to have a 60-day dispositive motion deadline instead of a 30-day dispositive motion deadline, just given the breadth and scope of what's happening here. So instead of the August 10th proposed date by the plaintiffs, it'll be a September 11 dispositive motion and motion and eliminate deadline. That's the other reason why I think additional time is necessary. I know the rules contemplate, and I mentioned this in another case earlier today, a 45-day prior to trial motion and eliminate, but this court puts motion and eliminate deadline at the dispositive motion deadline. You're in the weeds of the facts, you're putting together your motions. This is also the time to think about evidentiary. So it may seem contrary, we're trying to dispose of the case or part of it, and we're also trying to figure out if we're going to trial, what evidence we need to have in or out. But at the same time, you're having to get in the weeds of the case, and it just makes sense for those things to get handled. I am also going to decline to add in a substantial completion deadline for written discovery. I understand the ask. I think it's the first time I've seen the ask in all candor. I understand the ask. I just don't believe that it's going to be necessary here. I trust the council and the parties not to be engaging in endless, supplemental, endless requests, endless things. That everybody wants to get to the heart of what the records are. Obviously, it'll depend on what's objectionable, what's provided, what isn't. But I think the parties can be efficient here in responding to discovery, propounding correct, limited discovery, responding to discovery properly. Let's have this case discovered and get it going. And I don't think we need to say that because we have expert deadlines when they are that are proposed by plaintiff that the court's adopting, that somehow we're going to constantly keep having things come out and then keep having to have experts supplement. And at the end, either party that has experts running wild, so to speak, I'm not saying that they would, but they run the risk that they're not going to recover those costs, because that's not a guarantee. And we still have a limit. It's the more appropriate limit these days than it has been all these years that I've been on the bench, because it was raised. But it's still, not a guarantee that they're going to get those costs back. So everybody should be very efficient there. And I think last but not least, the party did agree that the expert depositions would be excluded from the 10 deposition limit, and we will accept that as well. Okay, so the court will prepare the scheduling order and order setting civil jury and trial and counter call from this discussion. That'll get out shortly. We've already tasked the state with preparing the order on the denying the motion to stay. 2026, that's, yeah. And I think we've got everything for now, and we'll see you when we see you, and we'll find out what happens with the appellate courts.
Just real quick, Your Honor, housekeeping, discovery motions, do we file those in front of you, in front of the discovery commissioner? How do you want to handle it?
Well, so here's the deal. This is not a business court case in designation. Whatever opinion I have on how this case moved from another department to this department, it is what it is. But we can certainly determine that this is a complex case, and that's really what Rule 16 contemplates. And this is a complex case, and I don't see any reason for you all not to come to the final source of the decision-making on discovery. And I will go ahead and deem this case complex. We'll add that as needed to any scheduling order or otherwise. But all discovery disputes can be filed directly with the district court, and the district court will rule on them to save not only time, but money in terms of how we get discovery dispute decision-making happening. Do not please overburden this court with discovery disputes if you can help it.
Thank you. Thank you.
All right, thank you.